When judicial discretion becomes deadly for innocent person. This is my personal reflection on the article titled, Newsom appointed judge who freed migrant before fatal stabbing said justice sometimes means a dismissal. The article was written by Elaine Mallon and Charles Krates, published by Fox News on August 14, 2026, and republished by Yahoo News. The opinions expressed in this reflection are my own. The events. According to the article and other published reports, Marcos Iriarte-Valdez was already facing felony charges connected with residential burglaries allegedly committed in Orinda, California. He had been released from custody under home detention and electronic monitoring conditions. On August 4, 2026, he was taken back into custody for allegedly violating a condition of that home detention. The following day, August 5, Contra Costa County Superior Court Judge Nichelle Holmes released him on his own recognizance and returned him to home detention. According to the Contra Costa County District Attorney's Office, prosecutors had opposed electronic home detention 3 separate times: at his arraignment, at his preliminary hearing, and again at the August 5 hearing concerning the alleged violation. The prosecution's objections were therefore not a last-minute reaction created after the tragedy. The warnings reportedly existed before the release decision. The Martinez police chief later stated that the electronic monitoring equipment apparently was not placed on Iriarte-Valdez until the day after the fatal attack. On August 6, one day after his release, Iriarte-Valdez allegedly attempted another residential burglary and stabbed 68-year-old Todd Stewart to death outside Stewart's home. Todd Stewart was not a participant in the earlier criminal case. He was an innocent member of the public who had no voice in the August 5 release decision but allegedly suffered its ultimate consequence. The real issue is what Judge Holmes reportedly knew on August 5, what California law required her to consider, and why she returned this particular defendant to the same form of supervision that he had allegedly violated. What California law says. California law does not treat home detention as an informal suggestion. California Penal Code Section 1203.018 establishes rules for certain pretrial electronic monitoring programs. Those conditions may require the participant to remain inside an approved residence during designated hours and permit supervising officers to verify compliance. The law allows the correctional administrator to return a participant immediately to custody, without another court order, when the person leaves the designated place of detention, when the monitoring equipment cannot operate properly, or when the participant no longer satisfies the program's eligibility requirements. A supervising officer who reasonably believes that a participant is violating program conditions may also return that person to custody without an arrest warrant. That appears to be what happened on August 4. The defendant was returned to custody. California Penal Code Section 1318 also requires a person released on his own recognizance to promise in writing that he will obey all reasonable conditions imposed by the court. A violation, therefore, means that the defendant may have broken the very promise on which his release depended. Most importantly, the California Constitution states that when a judge grants, reduces, or denies bail, the judge must consider protection of the public, safety of the victim, seriousness of the offense, the defendant's criminal record, and the probability that the defendant will return to court. The Constitution then says, public safety and the safety of the victim shall be the primary considerations. The word is shall. Public safety is not described as an optional consideration. The Constitution also requires the judge's reasons for granting or denying bail or release on personal recognizance to be stated in the record and included in the court's minutes. Discretion after a warning. California law did not necessarily require Judge Holmes to keep Iriarte-Valdez in custody permanently merely because some monitoring violation occurred. The law gave her discretion. But discretion does not erase warning signs. Discretion does not mean that every available choice is equally responsible. And discretion should not become a word that ends all examination of a judicial decision. According to the reporting, the prosecution objected repeatedly to home detention. The defendant was accused of burglarizing residences while occupants were present. The existing home detention arrangement had allegedly been violated. The defendant was returned to custody because of that alleged violation. Judge Holmes then returned him to substantially the same arrangement. The monitoring equipment apparently was not installed before he was physically released. The following day, he allegedly committed another residential burglary and killed Todd Stewart. In my personal opinion, this resembles a casino player taking another chance after losing the first wager. But the judge was not gambling with her own safety. The risk was imposed on people who had no participation in the decision. Todd Stewart allegedly paid for that gamble with his life. As a former prosecutor, Judge Holmes served as a deputy district attorney for approximately 12 years before becoming a judge. She therefore knew or should have known how serious is the prosecution's reasoning. She should have understood why residential burglary creates danger to homeowners. And she should have understood that an electronic monitor does not physically prevent another crime, especially when the monitor is not yet attached. The defendant, if convicted, will be held responsible for his alleged actions. But that does not end the examination of the official decision that placed him back into the community after an alleged violation. The authority to make a decision does not prove that the decision was competent. Discretion identifies who was permitted to choose. It does not establish that the choice was reasonable, responsible, or worthy of continued public confidence. If a physician, nurse, pilot, police officer, or engineer makes a professional decision that contributes to a preventable death, society examines whether that person remains fit to make similar decisions. Judges should not be automatically exempt from the same basic principle of professional accountability. The death of Todd Stewart does not, by itself, prove intentional judicial misconduct. But it creates a compelling reason for an independent and public examination of Judge Holmes's judgment, her compliance with California's public safety requirements, and her fitness to continue making decisions involving the release of potentially dangerous defendants. A private conclusion that the judge merely exercised discretion would not be enough. Final reflection. Judicial discretion did not wield the knife. But judicial discretion opened the jail door. Without that discretionary release, Iriarte-Valdez would have remained in custody. He would not have been free the following day to allegedly kill Todd Stewart. The discretion was therefore not the direct cause of death, but it was an indispensable link in the chain that made this death possible. A judicial decision can be legally discretionary and still be catastrophically wrong. When a defendant allegedly violates home detention, the response should not depend merely on hope that the same arrangement will work better the next time. California law provides authority to return a violating participant to custody. It recognizes that willful departure from home detention may constitute escape. It requires defendants to obey release conditions. And it declares that public safety shall be a primary consideration. The law therefore supplied warnings, standards, and possible consequences. The question is why those protections apparently failed when they were needed most. A reprimand issued months or years later cannot restore Todd Stewart's life. Justice that arrives only after an innocent person is dead is not prevention. The central question is not simply whether Judge Holmes had discretion. The central question is whether any meaningful system exists to examine and interrupt judicial decisions when discretion becomes an unjustified gamble with the lives of the public. Or the most honest answer is that discretion killed Todd Stewart. If there was no discretion, the would have protected him. Discretion allowed the judge to act on her own whim. If Judge knew that by violating the law she could be held responsible for consequences, she would never allow this lawlessness. I personally consider that discretion is a toxic word in judiciary and legal system.